each side will have 15 minutes to present their sides, and the appellant may have up to 5 minutes for rebuttal. So we're ready to proceed.
Thank you, Your Honor. I would like to reserve 3 minutes of my time for rebuttal.
That would be fine. Thank you.
Good morning, and may it please the court. I'm Jacqueline Corgan. I represent the appellant in this matter, Mr. Daniel Ott. Mr. Ott raises 3 assignments of error in this case, but the key issue before this court today is the question of whether the trial court committed reversible error when it allowed my client to go to trial pro se without first ensuring that he was actually knowingly, voluntarily, and intelligently waiving his right to have an attorney represented in that trial. Now, this denied him his rights under the federal and the state constitution, because essentially what the court had allowed him to do was go on without counsel, without first ensuring on the record that he was knowingly, voluntarily, and intelligently waiving his right to counsel by having the kind of colloquy with my client that is required by Criminal Rule 44 and case law interpreting that rule. Now, what the kind of colloquy my client should have had was a discussion in open court with the trial court, where the court would inform my client of the nature of the charges and the statutory offenses included in the charges, that she was supposed to inform my client of the range of allowable penalties that he could face if he were found guilty. He needed to be informed of the possible defenses to the charges and possible mitigation. And also he needed to be informed of other facts necessary for him to have a broad understanding of the whole matter. And that comes from the Ohio Supreme Court's decision in State v. Martin and in other cases. Because the goal with this is to ensure on the record, where future courts can see it, like this court, that the defendant is aware of the dangers and disadvantages of self-representation so that he knows exactly what he's doing when he exercises the concurrent right that he has under Ferretta to represent himself. But we have to ensure that the person actually knows that what they're doing and what they're getting into, and it has to be done on the record because they have to be able to waive the right to counsel knowingly, voluntarily, and intelligently. And in this case, there were 2 court appearances that are in the record in which my client's lack of counsel was mentioned, but other than very brief discussions about, if you go to trial without a lawyer, you're still going to be required to comply with the rules of evidence. And, last time you were in front of us, we had a discussion about following the rules of evidence. That's the sum and substance of the two discussions the trial court had with my client about his decision to proceed pro se. And that was an error. And as I've outlined in the brief, there were many, many reasons why that turned out to be extremely prejudicial to him. Not just because of the ultimate outcome, which was that the trial court found him guilty, but there were many, many ways in which it's clear that my client would have been helped by having counsel represent him during the trial in this case. And because he didn't have that proper colloquy, we're urging the court to reverse his conviction and remand it back to the Stone Municipal Court for a new trial so that he can have proceedings with an attorney. Now, I will acknowledge that the state is arguing that prior decisions from this court have been that in situations like this, where it's a misdemeanor offense, and that it's an uncounseled verdict or an uncounseled plea, that the remedy is to merely vacate a jail sentence that had been imposed. But I would submit to the court that there is a conflict now with the 5th District and explicit conflict with the 5th District since they decided in May of this year a case called State v. Walmsley. And I submit that as supplemental authority to the court that in another domestic violence case in, I believe, Ashland County, that somebody under similar circumstances was not given the full colloquy that State versus Martin requires, was not well informed about what they were doing and what they were facing, proceeded pro se, was found guilty, and the 5th District Court of Appeals, relying on an Ohio Supreme Court in a juvenile case, in an OVI case, of State versus Bode, held that even in misdemeanors, the mere fact that you have the potential for being confined, doesn't have to be in prison, can be confined in jail, demands that a conviction be reversed and remanded for a new trial when the person has not on the record been given the colloquy where we can ensure that they are actually knowingly, voluntarily, and intelligently waiving the right to counsel. In addition, the Walmsley Court from the 5th District has held that the lack of a proper colloquy under State versus Martin actually strips the person of the opportunity to make an informed choice as to whether to knowingly, voluntarily, and intelligently waive their right to counsel. And so without that choice, my client, if he'd been given if he'd been sufficiently advised as to the dangers he was facing, he could have made a different choice and opted to have counsel represent him. In addition, as we've said, this was a domestic violence case. I think one of the things that would fall under the other facts necessary for the defendant to have a broad understanding of what he's facing, I think with a domestic violence conviction, for example, one of the things that a trial court would probably want to include under the other facts category is the fact that a domestic violence conviction, if there is a subsequent charge of domestic violence, becomes elevated to a felony offense. And in addition, even a misdemeanor domestic violence offense can put somebody in a situation where they're unable or disabled under the law to possess a firearm under Ohio law and potentially even under the federal law. So if, for instance, if my client possessed a firearm today and was caught with the firearm, he could potentially face federal charges. So those are some of the other facts that my client ought to have been advised of.
How far would the advisories have to go from the trial court before it becomes becoming an attorney and advising him as counsel? Isn't there some point where you have to advise him that, gee, you might be jeopardizing future employment if you have a DV on your record? I mean, how far does it go before you stepped over the line and now you're not acting as trial court anymore, now you're acting as the guy's attorney?
I would hate to say that would be a case-by-case basis, but I think, and I understand that would be a difficult question initially, but I don't think that a court has to go through the entire list of the potential collateral consequences for each offense. It's just that we know from the face of the statute on a domestic violence charge, for instance, that the next one is going to be a felony. We also know that being caught with a firearm could be a federal offense with this type of charge. I don't think the court needs to say much more than, if you are convicted, you could face collateral consequences that right today seem unrelated to the charge, but they could include employment consequences and an elevation of other offenses too, if you're subsequently charged. And I think that may be where the court could stop. It would be up to counsel then to look through the exhaustive list of the collateral consequences and say, if you're convicted of this, you're going to be prohibited, for instance, from working in a school, or you're going to be prohibited not just from carrying a firearm, but you can't get a concealed carry license, but you also can't even have the gun. You can't have any ammunition. It doesn't matter whether it belongs to your wife. The fact that it's in a house is enough. I think that's the kind of detail that an attorney would need to go into, but I don't think the court needs to go into. I think it needs to inform the person that there could be potential collateral consequences if that's the case.
He was never informed of any of those things.
None of those. No. In fact, he was not informed of any potential defenses to these charges, no mitigation, no range of allowable penalties. You know, I could sentence you up to 180 days in the Summit County Jail if I so chose. None of that was told to my client. All that was told to him was, you're going to have to follow the rules of evidence, and oh yes, you're going to have to subpoena your own witnesses. And I'm not sure how much time I have left for this part of
You
it.
have over 4 minutes if you want to keep them, that's up to you.
No, I would also like to move on just very briefly to the other two assignments of error, which first of all is that the trial court, which has the discretion and actually the control over the courtroom proceedings and can, on its own initiative, shut down improper questioning, allowed a lot of hearsay and other inadmissible evidence into the trial in this case, thus abusing its discretion and committing plain error. And while, yes, there is a presumption that a trial court sitting by itself in a bench trial is expected to ignore improper evidence, that presumption can be overcome by indications that the trial court actually relied upon improper evidence when it made its decision. And we have that in this case. On at least 2 instances, the court referred to testimony by a police officer indicating what the alleged victim in this case had said. You know, she told officer so-and-so this per his testimony. And so when the trial court explicitly relies on that in a couple of instances in its written decision, that overcomes the presumption that the trial court is presumed to ignore the improper evidence. But there was a lot of it. There was a lot of hearsay as to what the victim said at the scene that came through the officer, was never objected to.
But she didn't testify as well, though.
She did testify as well, but her testimony was slightly different from the testimony of the officer and from the information that she had given in the police report. So there were some conflicting accounts.
Now you're in for rebuttal time.
Okay, thank you, Your Honors.
Morning.
Good morning. May it please the court, my name is John Scavelli, and today I'll be representing the city of Talmadge, state of Ohio. As spoke about by Mr. Ott's counsel, there are 3 separate assignment of errors. As his counsel, we're going to focus mostly on assignment of error 1, and if we end up having time, we'll move into assignments of error 2 and 3. We feel that the standard of review for assignment of error 1 should be abuse of discretion. There's not a lot of case law to discuss what the standard review should be. There is a first district case, State versus Burrell, which states that it is abuse of discretion. Mr. Ott's brief talks about that it should be possibly de novo, but there isn't any concrete case law on that. The only concrete case law seems to be the first district that says it should be abuse of discretion. We would argue that the trial court did not abuse its discretion in the way that it handled the criminal rule 44 waiver in this particular case. I think it's important to talk about what criminal rule 44 actually says, and that has a really that has a bearing on what we're talking about today. And it says the section that matters, which is section B, where a defendant charged with a petty offense is unable to obtain counsel, the court may assign counsel to represent him. When a defendant charged with a petty offense is unable to obtain counsel, no sentence of confinement may be imposed upon him, unless after being fully advised by the court, he knowingly, intelligently, voluntarily, and knowingly waives that. So what does that mean? What do you have to show that the person knows before they can knowingly waive that? And as counsel for Mr. Ott says, the courts have said that the court should explain the nature of the charges, statutory offenses included in the charges, the range of penalties, possible defenses, and possible mitigation. Now, do they have to go through a list? Well, you're supposed to have a written form if we're talking about a felony case, but in a misdemeanor case, you don't have to. You can just do it by talking. And do they have to go through each one of these things? They have to have a checklist. They have to say possible defenses, check. Mitigation, check. All those things. No, they don't. This can be something where there is substantial compliance, and there are many cases to substantiate that. So what are we talking about when we're talking about substantial compliance? As long as these things are mentioned or talked about in some way, then we can say there's compliance. In this case, it's pretty clear that explicitly these things were not talked about. But we're going to argue one step further, and we're going to say that there can be implied waiver. And there's two cases I'm going to focus on that talk about implied waiver. There's a 3rd District case, State versus Campbell, 10th District case, State versus Hook. And both of these talk about that you can look at certain facts talking about the criminal defendant. In this case, you look at the background, the experience, and the conduct of the defendant to determine whether or not they had enough knowledge that they could impliedly waive the Criminal Rule 44 rights. In this situation, Mr. Ott was not the normal criminal defendant. He was not somebody who just came off the street and had no idea what he was doing. We can see that by how he handled himself. Right? When we talk about what you need to know, how you need to understand what you're doing, it's important, first of all, that Mr. Ott did decide to move forward pro se. There is a 9th District case, Cuyahoga Falls versus Heard, where this court found that somebody who had no choice in the matter, who was told you're going to trial, it doesn't matter if you want an attorney or not, that's a different story when we're talking about Criminal Rule 44. In this case, Mr. Ott knew, right? He was talked to by the judge. She says to him, you have the right to a lawyer. We'll appoint one for you if you can't afford it. And then she tells him, look, if you don't get a lawyer, we're not going to bring the witnesses for you. You can't rely on the state to bring the witnesses for you. You're going to have to do that yourself. And that if we come back to the next hearing, we're going to go forward, and you don't have an attorney, you're going to have to do it yourself. So she tells him, and he says he acknowledges it, he understands, and decides to move forward. And at that point, he goes ahead to talk about his own discovery motions and his own motions he's made. So what other things happen that show us that Mr. Ott knows what he's doing?
Well, and that's the key phrase, isn't he knows what he's doing, meaning how to proceed maybe as his own counsel and how to do discovery, how to question witnesses, those type of things. But obviously there's more to it than that.
Of course. Yes.
So I guess that's what I'm interested in regard to that, because the appellant is saying that none of the consequences of proceeding, especially on the domestic violence with all the collateral consequences, were explained to Mr. Ott here.
Agreed. I would touch back onto what Judge Schaefer asked, where she said, how far do you actually go with these things, right? So we're talking about collateral. What are the penalties here? The penalties are the time of incarceration. The penalties are possibly the firearms issue, but I don't know if those are really even the proper things for a court to be talking about, especially the firearms issue. But what does the court have to say? And the question is not so much, I don't think, what was told to the defendant, but what the defendant understood. And if you can tell from the record if he had the requisite knowledge to understand those things, and I do believe that we can see that. If you look at what he did and how he handled himself throughout this case, he definitely understood how the system worked.
Well, again, how the system worked, did he understand, was there something in the record that demonstrates that he understood that if he was convicted again of a domestic violence, that it would be a felony?
I don't know that there's anything, I'm positive there's nothing in the record that shows that. But I guess what I'm saying is when we're looking at whether there's an implied waiver, we're looking at whether or not there's something there that tells you this person is sophisticated enough, he understands what's going on. And I do think there are things that show that.
So so what basically you're saying is, with an implied waiver, we shouldn't care about whether he understood the consequences of obtaining a guilty verdict against him?
No, I don't think that's true. I think it's very important that we look at those things and we consider that. I'm actually going to argue in the alternative here in a second. However, I do think that what you can do when you're talking about implied waiver, and I'm not saying it's necessarily what we should do, it's what we're arguing at this point. But I think what's important, as you say, is this someone, we tell this is someone who understood those things and had the capability to know what he was doing when he waived his counsel. And I do think there are indications of that. There are several things. He filed a motion to dismiss before the trial. He objected to a police officer reading his report. He introduced exhibits. He challenged the qualifications of witnesses. He objected to hearsay. He made a criminal Rule 29 motion at the appropriate time, which is something that a lot of lawyers, new lawyers especially, forget to do. He cited case law in his closing argument. Counsel for Mr. Odson argued that that case law was off point, but if you look at it the way his strategy was, it really wasn't off point for what he was arguing. He clearly understood the elements of the offense, by the way he argued, and he questioned the nature of the injury that the victim had and whether or not she had the capacity to testify. And we're saying that does not explicitly state, yeah, he knows what these penalties are. 100% doesn't. You're correct. But we think that you can imply his knowledge from his actions in the way that
How would
he
you
handles it.
apply that? Just because he knows how to play an attorney?
Sure, agreed. I would say that you can say that if he understood these things, that he understands how the rest of it works as well. But, I mean, I can see where you could argue against that as well, 100%. I would say that part of what Mr. Ott's arguing is that he didn't do this as well as a lawyer. And that's true, he didn't. He made mistakes a lawyer may not have made. He made mistakes maybe a new lawyer might make, but probably most lawyers aren't going to make, right? We're not arguing that he is out there and he's as good as an attorney. We're not arguing that he knows what he's doing even. What we're arguing is that he showed that he had enough knowledge, that he knew what he was doing. And I think that's all that you need to show. And you need to show that he had the requisite knowledge to know what he was doing. Now, moving on to what we think of what the possible remedy would be here if the court decides against our argument of implied waiver. If that's the case, we would argue that the proper remedy here is just to vacate the jail time. Now, there is a prior precedent from this court and from the 8th District and the 2nd District to argue that that's the case. So what you do is you just go ahead and you get rid of the jail time. In this case, he didn't do any actual jail time, he just did suspended jail time. So that would just be wiped out, and the remedy has been properly administered. When we look at the reason for that, just go back to the text of Criminal Rule 44. And it says, no sentence of confinement may be imposed upon them. Okay? So what we're talking about is what's important here is that there's no jail time imposed. It's no different than any other case where there's no possibility of jail time, there's not necessarily a right to attorney, and there is precedent to support that.
Now, on the precedent that we have, that you cited from this court, that was before the Bodie case, and the Supreme Court does talk about really that there's no difference between when it comes to uncounseled pleas and proceeding without counsel between a misdemeanor or a felony case. What impact do you think that has on our decisions? I mean, I understand it's not exactly on point, but there's that broad language, maybe indicating a departure from the prior stance.
Possibly. I think that at this point, you just go back to Criminal Rule 44 and you say, what does this mean, or what are we saying? If that's the case, then I think at some point we're going to have to appoint counsel for speeding tickets because it's the same issue. Right now we say maybe that's minor, maybe we're going too far, but is disorderly conduct necessarily minor? And that's a minor misdemeanor. At some point, when are we going to say that this doesn't matter? And what the overriding issue has always been if there's a possibility of jail, then you have the right to appoint counsel. Right? It's not if there's a possibility you can't own a firearm. It's not if there's a possibility you might have an enhanced offense someday. It's always been if there's a possibility of jail time. And for that reason, I would argue that that's how the standard should stay. If not, we're going to get to the point where we're appointing for every possible minor misdemeanor because the same possibilities are there, right? This is something that goes on somebody's record. It's something that could taint their name. They could have a possibility of
Well, I think it would be everything except a minor misdemeanor, that there's no jail time.
Sure, 100%. But I think, like I said, the issue there is, and that's what we're talking about when we're talking about Criminal Rule 44, the reason why you just vacate the jail time is because what we're talking about is if there's no possibility of jail time, then there's no constitutional right to appoint a counsel. And that's what we're talking about. So there's no right at that point. You can hire your own, but there's no constitutional right. And Criminal Rule 44 is not constitutional. It's based on constitutional principles, but a violation of Criminal Rule 44 is not a constitutional violation, as opposed to it's just a violation of the rule itself. And we feel that that reading, especially the 5th District case, Wamsley, is in contradiction to Criminal Rule 44 itself. So based upon that, we would argue if the court does find that there was no implied waiver, we would argue that the proper remedy should be just the vacation of the jail time. I'm not sure how much time I have left.
You have over 2 minutes.
Okay, I'm just going to touch base very quickly on the next two assignments of error. We would state that there was no objection to most of these things, as stated by Mr. Allen's counsel. That means that you have to show it's plain error. So not only did these things, were these violations, they also affected the outcome of the trial. Here we have several things that did not do that. We had testimony from a police officer that was later then spoken or testified to by the victim herself, who was able to be cross-examined. We also have a situation where a police officer talked about being in the home before, or other officers knew that he lived there. The only possible issue that could be would be go to the element of family or household member, which wasn't an issue in the end because there was testimony that the victim and Mr. Ott had a child together, which negates that completely. Or the other acts issue that was brought up, that's not an issue because there is case law that we've cited that states that unless you say that you were there for a crime, right, it's not prejudicial just to say the police had been to your house before. So we do not feel that that is the issue. Finally, the issue of ripping her clothes, which Mr. Ott makes a big deal about, is one where, yeah, sure, maybe it says this guy's a bad guy, right, and maybe that's objectionable. But does it rise to the level of plain error? Is this enough where we're saying this trial would have been different had it not been for that? And I think there's more than enough evidence. He pushed her in the wall, he grabbed her shirt, threw her into the floor, threw her over the couch. He caused red marks and bruises to her. There is more than enough evidence to prove beyond reasonable doubt that this was domestic violence. And just to touch base, they're not arguing sufficiency, but there's sufficient evidence. But we also feel that there's more than enough evidence, and it's looked at correctly by the court, so that there's not it's not against the manifest weight of the evidence as well. Just to touch on the third point. That's all we're going to talk about today. If the court has any other questions, we'd be happy to answer them.
I don't believe so, thank you.
Thank you.
Thank you, Your Honors. With respect to counsel, he asked, when do we say that this doesn't matter? And when we talk about this, we're talking about a person's Sixth Amendment right and rights under the Ohio Constitution to counsel. Under the Bodie decision, anytime there's a possibility of jail time, there is a right to counsel. And I would like to quote from the Ohio Supreme Court's decision in Bodie at paragraph 24, about midway through the paragraph. It says, an attorney is crucial whenever there is the possibility of custody. That is what an attorney will protect against. And when I emphasize the word possibility, that's the court's emphasis. The court itself wrote that in italics. Now, Bodie, I would submit to the court, even though it is not exactly on point with this case, it didn't deal with a domestic violence misdemeanor. Bodie is an indication as to how the Supreme Court of Ohio would rule if it faced the question in this case. And the remedy then is not merely to vacate a jail time sentence, keeping in mind that the prior precedent that counsel has cited was prior to the decision in Bodie, and again, prior to the 5th District's conflicting opinion in Wamsley. So, as far as the standard of review is concerned, yes, we are arguing that it appears to be de novo. There really isn't much case law on this, but when it comes to a constitutional right and the denial of a constitutional right, this is not something that the courts have said is an abuse of discretion. That the court has within its discretion the ability to deny somebody their constitutional right, especially to counsel. Furthermore, as far as an implied waiver, the decision in Glasser versus United States, which is cited in Bodie and I believe or at least in Walmsley, which is at 315 U.S. 60, indicates that this right right, the Sixth Amendment right to counsel, which is created by the Constitution, is not merely a rule of procedure. Strict compliance, therefore, is required, and there is a presumption against waiver. So that goes against the idea of an implied waiver. If you have to strictly comply and ensure on the record that the defendant knows exactly what they're doing and knows the dangers and disadvantages of self-representation, then implied waiver is not sufficient, especially, as Bodie points out, when there is the possibility of confinement. And as far as my client knowing what he was doing, yes, he filed a motion. Yes, he, as Judge Carso aptly put it, played at being a lawyer. But it's the same kind of situation where, yes, I know how to change a tire and I know how to change the oil in my car, but it doesn't mean that I'm equipped or trained to resurface the brake rotors. Okay, this is something that people often think that being a lawyer is something they often think that they can do themselves because we have LegalZoom and other, you know. Thank you very much, then, and I again ask this court to reverse and remand. Thank you very much.
Thank you. The court will take the matter under advisement. We'll issue a written opinion that will be sent to both sides, as well as we'll release on our website.
Thank you, Your Honor.
Thank you.